Right now, we are listening to live testimony in the courtroom on the Knight case. This is an officer who responded to the scene. This is interesting testimony because he is talking about how the roads were wet and how there were pills found around the victim's body. Joining me now is prominent defense attorney out of L.A., Adam Sostrin. Adam, thank you for joining us.
I love that. I don't know if I'll take prominent, but I'll take it.
It's good to see you. So
good to be here.
What do you think about this? You know, this whole case hinges on a legal technicality of whether or not this is self-defense of others or whether or not there was an imminent threat, an imminent danger that would cause self-defense to be a valid defense. So yesterday we heard eyewitness testimony saying that the bike spun out of control, and then you hear the defense saying, no, the bike fishtailed around and bucked up the front tire, and the family was in danger. What do you make of this testimony we're hearing right now from the officer? Right, but don't you think that this is circumstantial evidence showing that this deadly force was excessive force in this case, that the roads were wet, that the victim on the bike was intoxicated, he had marijuana in his system, there were a bunch of oxycodone pills spewed out next to his body, and we heard from the medical examiner this morning, let's not forget, where the medical examiner discussed exactly where the bullet lodged in the brain of the victim. I don't know if you heard that testimony earlier, Adam, but the bullet did not lodge the front of the brain, which means the direction of the bike may not have been facing the defendant, but it doesn't mean that it also wasn't facing the defendant's family. What do you make of that as a defense attorney? Right. Okay, so I just got news from the courtroom. We're monitoring it live. We're following it real closely because that's what we do on the Law and Crime Network here. We keep a close watch in these courtrooms. The jurors in the courtroom just broke for lunch, so we're going to spend the next time recapping what we've heard on some of the eyewitness testimony yesterday, some of the medical examiner testimony today, and also while we have you here, another thing we're going to be covering and keeping a close watch on is the civil trial out of Nevada. This is the David Copperfield case where an audience member was selected to be a participant in one of the famous disappearing acts. During the act of this disappearing, which has been performed by David Copperfield, world-renowned magician, many times, thousands of times, without incident, this audience member tripped and fell and is claiming serious brain injuries. We have a preview of that clip, and let's take a look at it now. This is a real interesting case for audience members to watch because we all want to believe in magic, and the illusion behind this magic trick is already revealed in the 13-page complaint that's been filed. We are monitoring this one really closely. Jury selection is in process, and opening statements are set to begin next week. But if we have any updates, we will go there live. Before then, I still have with me Adam Sostrin, defense attorney out of L.A. Adam, you know, these kinds of personal injury liability cases always get me. I practice personal injury law, and I have my suspicions about this case, and I want to get your feeling. Do you feel like this is a case that is a legitimate trip and fall where he suffered serious bodily injury? Or is this a case where they want to get hush money, or they want to bring a claim because it's deep pockets? Because in the complaint, not only is David Copperfield named and all of his entities as does, we also have named MGM. So I know it's going to come down to a battle of the experts and whether or not the medical evidence is pre-existing or not. But what's your take? Is this a legitimate case? Because everybody loves David Copperfield. Okay, so it'll be interesting to see what the testimony actually reveals in that case and what opening statements are going to reveal as a narrative of what we can expect to see. So far, the defense has been pretty tight-lipped about what we can expect to see in that case. But what we did hear from the package that we just previewed is that the injuries were pre-existing and all unrelated to any trip and fall. So We shall see. We'll keep a close look on that. For now, we will refocus our attention back to the Knight case, because that's what we do have live in the courtroom. The jurors are now on lunch break, but we are prepared to give you some insight into yesterday's opening statements. This is day 2 of the trial, so let's take a look. You are listening to the opening statements of the prosecution on the William Knight case out of Ohio. With me is our guest, defense attorney out of LA, Adam Sustren. Adam, so what do you make of this so far? As listening to this, it seems like excessive force. You know, he went there to go find out if the bike was in fact the stolen bike that he thought would be stolen. He goes there with a loaded gun, 5 rounds loaded, you just heard it there, and he takes matters into his own hands. If he really believed that this was a stolen bike of his son-in-law, Gil Curtis, shouldn't he have brought a cop with him there and not shown up with a loaded gun?
Yes.
Right, but let's make sure we point out so everyone knows he did have a license to carry. It wasn't illegal for him to be carrying the gun. He did have a concealed weapons permit. Though he recently got the permit, it wasn't illegal for him to be armed. However, he did shoot and kill an unarmed man over a dirt bike, which to me seems like excessive force. While the cops were on the phone, they couldn't just wait for the cops to get there. I mean, from my point of view and from a juror's point of view, I'd be thinking, well, gee, we know where he lives. We know where the bike is stored. Let's just get the police involved and let the law take care of itself and not take someone's life. And just a key thing to pay attention to in this case, while the state has the burden to prove this case of murder beyond any and all reasonable doubt, it is the defense burden to prove self-defense in this case, but not by a much lower standard. The standard is clear and convincing evidence. So let's take a look at the next round of opening statements that while the courtroom is still on their lunch break. Let's take a look. This concludes the prosecution's opening statements in the William Knight case. There you can hear the prosecution attorney giving the lay of the land of what happened before the fatal shot happened and lodged into the brain of William Knight. One interesting thing that I'd like to dissect a little bit further with our guest who's with us from LA, defense attorney Adam Sustren. Adam, in this case, the jurors were taken to the scene before opening statements. So here during opening statements, we're getting pictures of the lay of the land and what happened. But what do you make of the jurors being taken to the actual scene? As you can see there, the scene where the jurors were able to see the exact place where the pills, the oxycodone were found by the victim's body, where the victim's body was found, where the cars were parked. Was that more prejudicial than probative? Why would they do this? What are the jurors thinking? Right. No, that's a good point. But it also is important to point out that in Ohio, that there is a burden on the defense to prove self-defense by clear and convincing evidence. So while the prosecution still must prove their case beyond any and all reasonable doubt, they carry the tougher burden. They have to meet their higher burden of murder. But they could get it could be a lesser. There's no doubt that he actually killed them. So really what's going to turn on this case, which is probably why it was important to go to the crime scene for the jurors to get a lay of the land, to understand where the cars were parked, where the bike may have, flipped around and fishtailed around and bucked up on the front tire. All of that is important to see whether or not the defense can prove by clear and convincing evidence that it may be self-defense. So speaking of which, the next thing we have for you to listen to, we are live right now monitoring the courtroom, but we also have previously recorded testimony and opening statements from yesterday while the courtroom is on lunch break. So you just finished hearing the prosecution's opening statements, and now we're going to go into the defense opening statements. Let's take a look. That is defense opening statements in the William Knight case, the dirt bike murder out of Ohio. With us is Adam Sustren, defense attorney out of LA. So Adam, listening to this, I have 2 things that come to my mind. Okay. One, they said that we will be hearing from Mr. Knight himself. What do you make of that? You think that's a good idea to put him on the stand and let him explain what happened those moments, or should we be allowing doubt to take over the prosecution's case? He shows up he shows up armed. He shows up armed with multiple people. He knows that he believes that this is the stolen bike and that this bike that's been posted for sale by Justin Badgett is of stolen status. They bring the title with them, and they are there to confirm and reclaim ownership of this bike. Why not call the police and get an officer to come with them to confirm the status of the bike and not go through all of this? I mean, what do you think the jury is possibly thinking? He showed up armed. So that could be maybe one of the lessers that could be provided in the jury instruction later if they can't meet the burden of murder. I'd like to take a look at some interesting testimony yesterday while the courtroom is still on lunch break right now. Those were just the opening statements from the prosecution and the defense that we heard. But yesterday we heard from eyewitnesses on the scene. Specifically, we heard from Justin Badgett. Justin posted the bike for sale. He was sort of a middleman. He was told that he could make a commission if he were to post the bike for sale, which he did, and he was there on scene when the altercation began to ensue when the title of the bike matched the serial number of the bike. Let's take a look at yesterday's interesting eyewitness testimony, because this testimony helps describe the circumstances leading up to those fatal last-moment shots. That is the cross-examination of Justin Badgett, the victim's friend, and also the man who posted the bike for sale. To further dissect this, I'd like to bring on our guest, legal analyst, Adam Sostrin. Thank you for staying with us, Adam. So what do you make of this testimony? Right, well, based on his testimony, but what we also just heard there at the end of the testimony, that was cross-examination, so it shouldn't bolster the prosecution's case, it should bolster the defense's case, and right before we came out of that, you heard the defense attorney say, or ask the question about how close of a friend he was to the victim, and I believe that's where he said he was like a brother. So isn't the defense going to show motive to lie or some kind of bias there because they want to hold someone accountable for his friend's death? Okay, and another relationship that I want to bring the viewers back to was testimony from yesterday. Another eyewitness, Ivan Orlando Stragling. This is the victim's uncle, and he watched the killing and the entire moments leading up to the killing and that fatal shot from the window of the house. So more testimony to listen to from yesterday while the jurors are on their lunch break. But we are watching the courtroom live, and it looks like they are coming back in. But let's take a quick look at yesterday's testimony, and as soon as there's something to bring us back to, I'll bring you back into the courtroom live. We are hearing testimony from a Dr. Jolie Bram. She's a clinical psychologist. Right now, it's a little bit slow in the courtroom. They're just building up her testimony, bolstering her. She's discussing her resume and her credentials and why she is an expert on being a psychologist, and great to talk on this subject. It's still not clear to me on why the state is calling her to testify. Adam, defense attorney out of LA, what do you think? Well, it sounds like she interviewed the defendant, and I'm just trying to figure out when. We're paying attention to the courtroom live right now, but before we go back into it, for those of you who are just joining in, a quick recap. This is a case from 2016 when the defendant it's out of Ohio, when the defendant went to go recover a stolen dirt bike of his son-in-law, Gil Curtis. When they arrived on scene and confirmed that it was in fact of stolen status, the serial number of the bike matched the title that they had in hand, and they wanted their bike back. An altercation ensued, some gunshots were fired, and the fatal shot was shot to the victim, Mr. Johnson. This is a case turning on whether or not this is cold-blooded murder or self-defense of others, because Mr. Knight is claiming he needed to shoot the gun to protect his family. Let's take a look at what this clinical psychologist is saying in the courtroom right now, because we are covering this live in the courtroom. Let's take a look. You're listening to live testimony of Jolie Brams, clinical psychologist and a prosecution witness. If you've been listening the last few minutes, we're in the William Knight case. Even though it's a prosecution witness, what seems interesting is after they've bolstered her testimony and by having her testify as an expert in her field, she seems to be making a case for the defense on why he might be acting out of fear, how much he loves and wants to protect his only child, his prized child. She seems to be laying the circumstances and the surroundings that would make it reasonable for someone in Mr. Knight's position to act in self-defense under the circumstances of that fatal night when he shot Mr. Johnson. With me, Adam, I wanted to ask you what you thought about that. Do you feel, though, because this is a prosecution witness, that the prosecution is strategically putting her on the stand to so it's not sprung on them later on the defense case? I mean, why else would everything I've heard so far, this is making a case for the defense's defense, which we have to remember in Ohio, the defense does have a burden of clear and convincing evidence. Why is the prosecution witness testifying for the defense? Now, we haven't heard everything yet either. We still have a lot to hear, and this is live testimony. But is that a strategic move? Okay, so speaking of the cat being out of the bag, I want to address, before we go back into the courtroom with the live testimony, unless there's something really interesting, we'll break right back in right away. But cats out of bags and rabbits out of hats, I want to bring up other trials that we're following here on the Law and Crime Network. Next week, we can plan to see the David Copperfield trial that's out of Nevada. This is a civil case where there was a slip and fall with an audience member when the audience member was part of a disappearing act. This disappearing act has been performed thousands of times without incident, but in this case, there was a trip and fall, and he is claiming traumatic brain injury and suing David Copperfield and MGM Studios and all the John Does of David Copperfield. We can take a preview of that, but another case we're also following here closely, and if you've been watching us here at the Law and Crime Network the last few weeks, is the Tex McIver case. This is a case out of Atlanta, Georgia. This is a prominent attorney who shot and killed his wife from the back seat of a car while her best friend was driving the car. He claims it was an accident. The prosecution says it was murder, and the motive was financially motivated. So far, if we've been following that case, it seems like the prosecution is having a really hard time meeting its burden to prove murder beyond any and all reasonable doubt. And I have to be honest, when I first heard that case, I thought, come on, he's guilty. He shot his wife from the back seat of a passenger car. It seems far-fetched. But as this has unfolded the last few weeks, it does seem like it could be an accident. So next week you can watch that as well live, and hopefully the defense will be putting on their case soon as well. And another thing to know is the Law and Crime Network has an app now, so you can watch these trials live, not only on our network, but on an app. That being said, let's go back to the courtroom live and listen to Jolie Brams, the clinical psychologist in the William Knight case, which is the dirt bike case that we've been following closely today. We're going to come back here for just a minute and have some legal analysis while they have a sidebar with the judge. So right now, actually, a very important question was just asked. Probably the key question of why she was called. Based upon your education, your experience, your training, your interviews with the defendant, do you have a professional opinion on what Mr. Knight was thinking that night? She actually said not only not a typical aggressor, but that he had more of a tendency to retreat. Right. It is helpful for the defense, and that's why they asked the key question right now about her professional opinion, which is the bombshell answer we all want to hear. And then they went into this sidebar, which is why it got quiet on our end and we couldn't hear anything. So if you were to speculate right now about what's going on in that sidebar, which as we can see on the screen, they're all huddling with the judge, what do you think the issue is? Were they saying basically that they should refer to the report, the written report that was already done, and not have such a conclusory statement or answer? Right. They are certainly taking some time there discussing it. I didn't hear an objection ahead of time either, but she didn't get to answer the question, which was the question we were all waiting for, because we all want answers. Like, why is this specific witness called to the stand, and what specific testimony does this witness have to offer to lend credibility to the prosecution's case, or to help the defense poke holes in the case? What were you going to say? Right. Well. Okay, well, if we want to see magical, we'll have to watch next week with the Copperfield case. But with this one, I guess we're just going to continue with the sidebar. It looks like nothing else is going on here. So let's talk about this case a little bit more.
Okay.
What do you think the jurors are thinking? Well, and as we know, the jurors going to have to weigh all the evidence and take it all into consideration. Let's go back into the courtroom live because the sidebar just ended. Let's see if she's allowed to answer the question and what she has to say. You are listening to live testimony of Dr. Jolie Brams. She is actually a defense witness called out of turn and is now being cross-examined by the prosecution. So due to scheduling conflicts, she's now on the stand. And before we have to let our wonderful guest go, Adam, I wanted to ask you just a couple questions, just listening to this and summarizing what she's saying. On cross-examination, it appears to me that he's asking her how much does she charge per hour, which was $300, that he sat with her for 3 hours, and she interviewed him, and she interviewed family members, and she had to prepare for actual trial, and now she's getting paid for her time here, that her opinion is not really reliable, that it was paid for and is biased. What are you gathering from this, and what do you think the jury is gathering from this? Right. Well, but they're also harping on the fact that she only interviewed him for 6 hours. It was sort of an isolated incident. He asked her probably 3 different ways whether or not her opinion would change if he convinced her that the facts changed. So he's really trying to undermine her testimony. I would say she's a strong witness. What do you think the jury thinks? All right, Adam. Well, thank you so much for your time and for joining us. I know you got to sign off and get back to your lawyering, which I totally understand. But thank you so much for joining us. And we're going to go back into the courtroom live and pick up this testimony with this witness, which is still on cross-examination.